sorry. Okay, I thought that was quick. All right, so you're Ms. Barlow.
Yes, sir.
Please come forward.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
All right. And just a seat there, and just state your name and spell your last.
My name is Bicka Barlow. I'll spell both names for the protocol. B as in boy, I-C-K-A-B-A-R-L-O-W.
Thank you. Ms. Taylor?
Thank you. Good afternoon, Ms. Barlow.
Good afternoon.
What city and state do you live in?
San Francisco, California.
What is your occupation?
I'm an attorney and consultant.
Are you a licensed attorney?
Yes, I'm licensed in the state of California.
I want to talk a little bit about your education to get you to become a lawyer. Did you do a bachelor's degree?
Yes, I have a bachelor's degree in genetics from the University of California, Berkeley.
Did you also get a master's degree?
Yes, I have a master's in genetics and development with minors in plant and molecular biology and cellular biology from Cornell University.
And then you went to law school.
Yes, I did. I attended the University of San Francisco School of Law.
All right. Do you utilize both parts of your education, your law degree and your master's in what you do?
Yes, actually I began using it when I was in law school and was hired in Alaska to assist in cases of DNA evidence back in 1993. So since that day, I've done almost primarily DNA cases.
You were in law school when that happened?
Yes.
Have you done any teaching?
Yes, I teach attorneys regularly. We have credits to keep their licensure, and I also occasionally teach for I'm a guest presenter in law schools around the area.
When you teach lawyers, what kind of topics do you usually teach about?
Oh, 100% about DNA evidence, and it's ranging from the DNA 101, the basics, to the most sophisticated aspects, including things like mixture interpretation, and now the application of probabilistic genotyping in the program.
How long have you taught lawyers about DNA?
I think the first time I presented was probably in 2000. So going on 20 years.
Do you still do cases and represent clients as well?
I've pretty much given up direct representation of clients. I find doing DNA cases takes up most of my time, and it's feel better for the community as
What professional organizations do you belong to?
Right now, I think I'm a member of the National Association of Criminal Defense Lawyers and the California Association of Public Defenders, I believe. And I used to be a member of the American Academy of Forensic Science, but I no longer
Have you authored any articles for publication?
Many years ago, an article that I was co-author in was published in the Plant Cell, which is a scientific journal regarding the work I did on my master's thesis. And I did also an editorial piece in USA Today many years ago.
Heard you say that you work as a consultant now. What does that entail?
Well, I've worked with lawyers who have cases that involve DNA evidence, and a lot of my work with those lawyers involves literally teaching them about DNA, because many people don't have any knowledge about it. That's why they're And I sit with them and explain what they have. I usually expect in their cases. And then I generally, depending on what the needs of the team are or the particular lawyer, I will help them work on defense strategy, discovery issues, preparation of motions. I write motions. And I also do trial work. I do hearings like this as the lawyer, not as a witness. And I participate as a lawyer in the trials.
How did you end up helping in Mr. Kohberger's case?
I believe that either you or Ms. Nassau reached out to me.
And what is your role?
I'm my understanding is I'm assisting in essentially understanding the case, helping to do discovery, and consulting on, right now, discovery issues.
In that capacity, have you helped us understand what we have and what we don't have with regard to DNA evidence?
I hope I have. I was allowed access to, I guess, the vast majority of discovery, and I do that and identify areas where discovery was missing and where I can continue to get more information.
I want to focus a little bit on one of the areas of discovery and why it's important to have an area of discovery. I want to talk about DNA profiles and what happens. In our case, there are 3 other unidentified male profiles. What are we missing?
Well, I believe at this moment we have all of the reports of the testing from my state police laboratory. What I believe was requested and what has not been produced is any direct information or documentation of whether those profiles were uploaded to the state or federal convicted offender or CODIS database.
I want to talk a little bit about the CODIS database. You said federal or state. There are 2.
Well, yes.
50+1.
Every state has their own state-level CODIS system that's essentially operated through software that's provided by the FBI, I believe, Federal Department of Justice. And each state has its own statutory scheme regarding what can be uploaded, what can't be, and what types of records should be in there. I'm very familiar with California's law. I'm not familiar with and each local crime lab has a thing called LSDIS. It's their local level database that they can upload things that are not even part of the state system, but that feed into the state system. And then the state level databases feed into the federal database, but because of different federal rules and statutes around what can be uploaded, not everything that's in every state database goes to the federal system. So there may be more in Idaho than Idaho actually puts up into the federal database.
Why would we want that?
Why would we want?
Why would we want to know if those other 3 unidentified male profiles have been entered into?
Well, I'm going to jump in. I believe we resolved this portion of the discovery proceedings this morning. That was my understanding. I'm not sure we're rehashing the particulars witness.
Where I don't think we resolved it. I don't think we have everything. I don't have an answer from the state saying we didn't upload those 3 profiles anywhere. We did nothing. If that's the answer, then I mean.
I thought that was the answer. Is that the answer?
I thought that had been communicated, and I thought that the lab personnel had communicated that those samples are not eligible to be uploaded to CODIS. It is my understanding that has been communicated to Ms. council.
So, you have been told that it wasn't uploaded, so there's no,
Correct.
that wasn't pursued.
Yeah, the samples did not meet the criteria for uploading to CODIS. That's my understanding. And I believe Ms. Jennings is the one who communicated that to Ms. Taylor. She's looking now.
That's fine.
Your Honor, if the answer is that they absolutely have not been uploaded to CODIS, then that's the answer.
That's what
I don't, I heard it now, I heard it now.
Okay. Great. Thanks.
I'm not sure I'm real comfortable with leaving it that way because she heard it before. This isn't a surprise, Judge, and I think it's unfair to characterize it that way.
Well, let's just get past it.
Yes, sir. Here to do that.
If that's resolved that way, then that's resolved that way. I think it's satisfied. So we'll sustain the objection. Because it's been answered.
All right, give me just a moment so I can move past that line of questioning. Ms. Barlow, one of the other areas is whether or not you have corrective action or irregular result reports.
Your Honor, I'm going to object. The state indicated this morning that we would reach out to the lab, that we had disclosed everything in our possession, that we will reach out to the lab. I do not think it is appropriate for counsel to call an expert witness as an attorney to discuss and relitigate a discovery dispute that was addressed this morning. It's not an appropriate thing for a fact witness to testify about, Your Honor.
Thank you. Any response?
Well, yes, Your Honor, I mean, these are things that have been in the defendant's third motion to compel for quite some time now. And I do know we have some of those results. We don't have the full scope of them. I understand the state says they'll reach out now, but I mean, we're months into this. I think maybe it might be helpful if the court understood why we want those, why they're important.
Okay, I'll overrule that, and just to get some understanding why that is important, even though the state has already said that they're going to provide whatever you need in that area. So,
Ms. Barlow, we requested 6 months before 6 months passes the date of the incident. Why did we want that scope of corrective action and working for the result?
Well, I think it sort of, preface your question, the corrective action logs are part of the lab's quality system. So is part of what they use to determine whether their quality system is well working. It's a way to track things like contamination events. It's a way to track things such as sample switching. It's a way to track the presence of unknown contaminants that appear in the laboratory. And it allows the laboratory to assess whether or not their own methodologies are working the way they're supposed to be. And one of the most important aspects of crime lab work is to not contaminate your samples, obviously. And so many laboratories now have to maintain these as part of their accreditation standards. And once a corrective action is noticed, somebody identifies a contaminant in a sample, for instance, the lab then goes through it as what's called a root cause analysis. So they will go back and look at whether a particular analyst has a particular habit that caused the contamination. They will look at things like whether some of their chemicals or reagents are contaminated, and that's what they're seeing. And they have to document that as part of the accreditation process. And so what it allows people like myself to do is to actually assess the overall quality, and it helps the jury understand the overall quality of the work that's being done in the laboratory itself, and whether the lab is following those protocols, and whether it lives up to the promise of the protocols to create demonstrable and reliable and accurate results.
Thank you. I'm going to skip ahead in my notes a little bit. genetic genealogy, are you familiar with those?
Yes, I've consulted on at least 3 of these, and then this one.
And the information contained in the genetic genealogy, I guess, testing and then the breeding the trees, is that something that is utilized to make decisions in a defense case?
Yes. And I guess the reason I hesitate there is because this is a brand new technology that's just been introduced to the court system. And there has not been a lot of litigation in this area. There's not been a lot of testing in this area in the sense of cross-examination, which I think is how most of these methods are tested in the crucible of the courtroom, essentially. And most of the issues that we find with DNA testing in the past, or that I have found in my career, I'm aware of, through engaging with other lawyers and scientists around the country, is that most of these things are found out through the discovery process. In other words, we get the information so we can do our own investigation. And I have in my mind exactly what I would do with this if I were given access to it.
Sure.
Ms. Barlow, thank you. I don't have any other questions, so hold on just a minute.
Oh,
Thank you. Any cross-examination?
No, thank you.
All right. Thank you. Any additional discussion?
Yes.
All right. Ms. Marlowe? Thank you. You are excused. You're free to stay as well. Thank you. Okay. Any more witnesses?
No more witnesses, Your Honor.
Okay. Now, I think we are prepared for argument. Is that right?
Your Honor, I believe we are prepared for argument, except I think the state wants to keep the issue open. Would you like to hear argument both times?
Your Honor, if I may, the city's position all along has been that no witnesses were necessary at all for any of this, so I think it makes sense for us to proceed to arguments. We'll get back with our experts and talk to them and see if there's even any need for us to call back these other witnesses and cross-examine them, but I think having the argument now is probably in the best interest of moving this case along.
Okay, thank you. So my understanding is this is going to be argued by Ms. Nassett.
Yes, Your Honor.
Your Honor, I'd like to start with kind of the overall of this discovery dispute and stuff that's still hanging out, including the stuff that the state claims they're going to comply with or are asking about, as well as what relates to the genetic DNA that we're asking for. To begin with, there's this proposition that there are witnesses here today that are unnecessary because this team is quite capable of articulating it to you and arguing for those things. Well, if that were the case, then we would not have had to go through this exercise to explain to you exactly why all of the information that we're asking for in this third motion to compel is critical to the state's case, to the defense's case. The state would have taken our motion to compel and complied with producing discovery, but they didn't. And so that is why 4 witnesses were required today to explain it to the court, because our word, our legal argument, is not being taken as the state says that it is, as justifiable reason to produce these materials. Now, we're having these arguments about, yes, we have this, no, we don't. And the simple solution, Judge, is just for you to enter an order, ordering all of the things that we have asked for in our third motion to compel, and that puts the state in a position of going to their agents, their Kiles versus Whitley agents that are obligated to produce evidence, hand them an order, tell them the court says that it needs to be produced, and then we will have it. We had to do that with the FBI reports related to the vehicle. We had to do that with the FBI reports related to the cell phone evidence. And while there's frustration on the state, I think what's really going on to a certain degree is that they're reliant on hundreds of law enforcement officers and other agencies to produce these materials to them. So we address all of that when you issue an order that says these things must be produced, and if they are not, then that they are going to potentially not be admissible in the jury trial in this case. That solves the yes we did, no we didn't solution about what has or hasn't been produced in this whole case. Now, as it relates to the G&A material that we are asking for, I will just briefly summarize what our experts have done for you today. Really, with Steve Mercer, we probably pretty much could have put him on the stand and ended right there, because it's crystal clear with his testimony that it is a minimum standard for this team to have this discovery in order to do our work. This discovery allows us to investigate the reliability of evidence. It allows us to make determination about what experts we need to hire. It allows us to make decisions about how we might cross-examine this evidence, how we're going to confront this evidence. And he also made it crystal clear to you that it is scientific evidence, because we began with a surface trace sample that has been extracted to DNA. A portion of that DNA went to an STR test, and a portion of that test went to some other lab that we really don't yet know. There's been discussion in pleadings about whether or not it's Othram lab or some other lab. I think kind of the general knowledge is that it's Othram, but we really don't even know that. So this original scientific sample from this surface trace DNA has been the product of multiple scientific experiments that we are entitled to have the underlying data on. And if we don't have that information, we are not going to be able to be effective attorneys for Mr. Kohberger. We then were educated by Dr. Larkin, and it was helpful to really understand what is this genetic genealogy and what's going on. And one of the first questions that the court asked as we began today was, if we have a sample and we have a buccal swab, why is all of this other material that you're asking for related to the genetic genealogy so important? And the first, the second, the third, and the fourth witnesses really all set that up. But in particular, Dr. Larkin explained to you that in that process, there are so many human decisions that are being made about the ultimate SNP sample that we can then, that was used to take further action. Some of those human decisions are what type of test was run. We don't know if it was a whole genome sequencing or if it was this next generation sequencing. That's something that's not being disclosed to us. Whole genome sequencing has a whole set of information that we may be able to look at and see if our STR sample that the state is relying on is indeed reliable, or if there are contamination issues, or if there are mixture issues. Next generation sequencing, if that was the method, has bioidentifying information that was used. Decisions that were made by human beings about what to include in gaps, what to strip out in gaps, and how to create the SNP sample that was then uploaded. Another critical piece of information that you learned today, Judge, is that law enforcement may or may not have used databases that they had the right to access. We don't know. We don't know what databases they uploaded to. We don't have the raw data to know if they accessed people that had opted out of the databases that they are allowed in, and we don't know if they uploaded information to MyHeritage. If we have that raw data, we will be able to make that determination. It could be that nothing is amiss. But certainly when we're having to fight this hard to get this information, it makes us quite suspect, especially when you've got a witness like Ms. Vargas with her experience who's saying this happens in the industry and I know because I work for law enforcement. And every single person in this courtroom should have pause when we are talking about forensic science that is no more than 5 years old. We know through the course of time with forensic science that there are all kinds of problems that arise when we rely on it. Teeth marks are a key example of where, years ago that was reliable science, and now it's been determined that it's absolutely not reliable science. We are dealing with something that is brand new and with all kinds of possible mistakes that could be made, and it's also possible that things that could have been completely appropriate. And finally, when it comes to Ms. Barlow, I think what you see, and what also you heard from Mr. Mercer, is this intersection between the science side and the legal side, and everything that our team is having to do with that, and the state as well. We've got to understand it. We've got to have the raw data to know what we need to do with that. And then we've got to figure out if we have defenses that we need to raise for Mr. Kohberger. So individually, each of these experts gave you the information that you needed to order a motion to compel on the genetic genealogy information that we've asked for. Cumulatively, it is overwhelming that we must have this evidence to do our work. Thank you.
Let me, I just want to make sure I understand this. So you have all the information from the labs and all that as regarding the STR. Is that right?
Well, Judge, with the exception of all of the emails, which was one of the things that we were having some discussion about. So we have some emails that we can tell there were other emails attached that weren't, or attachments that are not there, and we have blank pages. And so the solution to that, simply order it. And then they'll take that to the Idaho State Lab and the FBI lab that's been involved and tell them that we need it all, and then we'll have it.
If it exists. We've had a couple of arguments about that already.
If it exists, and I'm not willing to concede that it doesn't, Judge.
And I understand that. I understand you're asking that. And I'll have some questions for the state too, because they're arguing that it doesn't. Whatever happened with the genealogy DNA doesn't have much bearing. Has no bearing on the case.
Well, right. That's their whole argument. That's why you had 4 witnesses today to explain why that is so critical. So that's a different argument than whether or not we have all of the Idaho State Lab and FBI lab STR emails and the emails that discuss genetic genealogy. Because we understand that they've said you shouldn't get anything related to genetic genealogy. But what we're also telling you is that we don't believe that we have all of the emails related to all of the DNA evidence related to STR. And if you enter an order, then the labs that are involved, it'll be clear to them that they've got to produce that.
You're suggesting, hey, it might be just fine. But you need to examine that to determine that it was just fine.
Are you talking about the genetic genealogy?
Yes.
There's the possibility of both. Honestly, I don't believe that it probably is just fine, Judge. If you're really asking me, we're having to fight so hard for this, and we have someone who's just testified who has worked for law enforcement that improper searches have been done. So I can make the assumption that it was done correctly. I can make the assumption that it wasn't done correctly. If it was done correctly, we probably wouldn't be fighting this hard about it. That's my assumption.
Well, right. suspicious about it.
Absolutely.
Why don't we get all this? But
Yeah.
let's just say, for the sake of discussion, that FBI went around the rules. Does it have any impact?
It does. It does for a variety of reasons. It's going to have an impact on the method of cross-examination. As a preliminary matter, it's probably going to result in a motion to suppress based on an improper search and privacy rights. So we're going to have breach
Whose
privacy.
rights would be violated there?
Mr. Kohberger's rights. But Judge, we can't make a decision about who until we know what the raw data is and what it says,
Sure.
right?
Well, I don't want to get into the Fourth Amendment issue there. I think that's in a gray area for sure.
It is, but you had two experts testify that these issues get litigated. And so if we're taking our experts' testimony as truth, and they're experts in this field, then these are issues that are litigated.
Right. Well, what it suggests is that that folks should probably be very cautious about sending their spit to some corporation. So, but I don't know how much that's going to bear on what ultimately happens, given the sequence that happened with Mr. Kohberger.
I disagree,
Wait,
Judge.
I know you do.
And I want to tell you why I disagree.
Okay.
Because we don't know what the sequence is. We can't articulate to you at this point, because of the lack of the data that we have, the sequence of exactly how they got to our client and what happened when and in what order. And so it's a big jump to assume that it did. And the other thing is that simply because some expert has uttered that's in the news media a certain number that is, attributable to what I guess people would say is a match, which would be inappropriate because a match is not actually testimony that should be elicited before a jury. All of the things that we talked about here today have an impact on those statistics. What happened in the databases with that genealogy research? You heard about how big the database is for 23andMe, and you saw the chart on how small the database is for what law enforcement has access to. Those have a drastic impact on the statistics that are coming out of that, and that are then being used to create what the state is saying is a tip to then do further work. Additionally, as it was explained to you, that whole genome sequencing, which is a huge amount of information potentially about our client, could have an impact on what the STR data is, which is a much smaller amount of information that the state wants to rely upon and give it this great big number. And so the statistics of all of this are a whole separate argument that are totally impacted by us having all of this information, and so the experts can look at it and tell us what we do with it.
So what happened with the SMP has big impact on how we got to STR.
Correct.
Or
Absolutely.
the connection of the STR
Absolutely.
to the DNA that was found at the premise.
It does. And what the state wants to say is we have A, surface trace evidence. We have Z, a buccal swab, and we're not going to tell you B through Y. You just take it as fact. And that's not how it works in the forensic science world. It's not how it works in a courtroom.
Thank you. All right, Mr. Knott,
Thank you, Judge. I got a lot to say.
I'm sure you do.
So, this wasn't where I was going to start, but let's start with the STR to SNP comparison, because that seems to be the thrust of their argument, that those things relate somehow. That could not be more incorrect, could not possibly be more incorrect. And how do you know that, Your Honor? Because not a single one of their witnesses could say that, other than Mr. Mercer, who, to your question, then admitted That's my hypothesis. If Your Honor looks, I would direct you to the affidavit we submitted from the manager of the ISP lab. And what she says in paragraph 9, this is the entire paragraph. I affirm STR data and SNP data cannot be directly compared. They have zero scientific evidence backing up this idea that somehow the SNP profile affects the STR analysis. Yet that's their argument here today. So they gave you 4 witnesses, but those witnesses didn't give you the evidence that they need to assert that argument. Now, let me take a step back and go back to where I was going to start. I signed up for this hearing to do the IGG piece of the argument. These other things, they were kind of to the side for me. This is why I turned around and looked at Bill earlier. But I will just say this. This idea that the court has to enter an order telling the state to do something it already has an obligation to do, I find offensive, frankly. I am an officer of this court. We all are. We are doing exactly what we represent to this court. And so the idea that, well, why don't you just sign something that says you have to do this? We have told you we've done it, Judge. And so you should accept that rather than just sign an order telling us something that we already have to do. Now, moving on to the IGG stuff. I do need to correct something that I wrote in my brief, and I hate doing that. I don't like starting arguments that way. But this one was not of my own making. I said in the brief that this was an issue of first impression in Idaho. That is no longer true. Just last week, exactly 1 week ago, Judge Whitney in Canyon County made a decision on this exact issue. Now, unfortunately, there's no written product yet available, and so I'm not able to provide that to the court. But it's out there. So this is not an issue of first impression anymore. And as soon as we're able to get our hands on something written, we will supplement it.
Well, can you tell me what he said?
I can, Your Honor. My only hesitation there is that I personally was not in the courtroom, and so I've only heard secondhand what was said. And so I'm a little hesitant to characterize it as it came through someone else. Thank you, Your Honor. Now, the court has heard from, by my count, 4 different defense attorneys today. 4. And yet, not once have we talked about Rule
I
16.
think there were 2 attorneys.
There were 2 attorneys plus 2 right here, Your Honor, that you heard from.
Oh, you're including the team.
Yes,
Okay.
who are both defense attorneys.
Yes.
And yet, none of them have mentioned Rule 16, which governs this dispute. Rule 16 governs discovery in Idaho. And what they have not been able to do is point to any subsection in Rule 16 that would require disclosure in this case. And I'd like to walk through some of those that they've flagged in their briefing but didn't mention at all today. To start with, though, I want to go to subsection B10. And the reason I'm starting at the end of the list is because this helps us understand how Rule 16 functions. So B10 allows for disclosure by order of the court. And it says, on motion of the defendant showing substantial need in the preparation of the defendant's case for additional material or information not otherwise covered by this rule, and that the defendant is unable without undue hardship to obtain the substantial equivalent by other means, the court may order the additional material or information to be made available to the defendant. Clearly, what Rule 16 contemplates is that there is information that does not fall into any of these discrete buckets that could potentially still be relevant to the case. But if that's the situation, then they're supposed to make a motion and show what the rule requires. They haven't even tried to do that. But it also tells us that it's got to fit into one of these buckets. You got to be able to plug it in there. So let's look at the buckets. First, they cite subsection A, mandatory disclosure of evidence and material by the prosecution. And I won't read the whole thing because it's a rather lengthy paragraph. But in there, it refers specifically to material or information in the prosecuting attorney's possession or control. Now, as to all the work the FBI has done, as I represented in the brief, because again, I'm an officer of the court, this is not in the state's possession. The FBI has it in their possession. And, you know, it's been a real pleasure working with Bill over the last few months, but even he is limited in his power, and he does not control the Federal Bureau of Investigation. So that subsection just doesn't apply. Moving on, if we look at B.
Would the FBI pay an order from the
Let me make one thing absolutely clear, and that is I am not in any way authorized to speak on behalf of the FBI. I don't know the answer to that, Your Honor. I can give you the legal answer, which is the FBI is not required to respond to orders of state courts. They are a separate sovereign. That I'm not implying that they would not. I'm just saying as a legal matter. So, what would this process look like if there were an order for us to produce this information? Well, we would then go to the FBI and we would submit what's called a TUI letter. And a TUI letter is a formal request for information in the possession of the federal government to us. And then their lawyers get involved, and we all know when lawyers get involved, stuff happens. So I can't say for sure what would happen. I can't speak for the FBI. I'm just making the point that this information is not in the possession or control of the prosecuting attorney.
So let me go to, this was in your brief, I believe, stating that to the state's knowledge, the only records that reflect the FBI's efforts to create defendant's family tree is the family tree itself. Notes jotted down by FBI agents as they constructed the family tree, and any records created to document the removal of the SMP profile from the Genetic Genealogy Services, there's parentheses S, more than one, pursuant to the DOJ policy. The state has not seen, nor does the state possess, these records or copies of these records. So that suggests that there are these pieces of evidence potentially that are available, but you just don't have them.
Correct, Your Honor. So what I was indicating there is that we do not have them in our possession. So we've been in contact with the FBI, and they've told us these things exist, but we don't have them. We don't. The state, the Idaho State Police, the Moscow Police Department, all entities of the state, we do not have that. We do not have possession of, for example, the family tree.
Well, what's the harm of getting that information to the defense and with some kind of protective order that they can't share that anywhere and they're going to keep it confidential, that they get a chance to look it over?
Sure, Your Honor. So, and this gets to the point that was kind of being made that we should assume that something bad happened because we're fighting this. But that loses sight of the fact that what the state's interest is here is in protecting the private information of the hundreds of innocent civilians on that family tree. Now, I get your point, Your Honor, that why don't we use a protective order and limit that? Well, does that help? Of course it does. But any time that you increase the number of people that have access to this information, it increases the chances that it will be inadvertently disclosed. So we don't have it currently. The defense obviously doesn't, or we wouldn't be here. If the court were to order it, if the FBI were to agree to provide it to us, you now have everyone on the state's team with access to that information, along with everyone on the defense with access to that information. And for what? That's the question here, right? What does it matter? And that question is still lingering. Why take that risk here for something that is not relevant to trial? Now, Your Honor just pushed defense counsel on how does this matter? And her response was, well, it could affect the manner of cross-examination. Cross-examination of who? These aren't state's witnesses. We're not presenting this at trial. So there's not going to be anyone up there for them to cross-examine about this process. Now, the other theories that they've gone to try and say, well, we need to have this information. One is the Fourth Amendment. That's been touched on a couple times now, including by one of their witnesses. I think as Your Honor's questions correctly pointed out, there is a fatal flaw in that argument, which is to assert a Fourth Amendment right, you have to have a reasonable expectation of privacy. Let's say, assuming that the FBI did violate some of these terms of service. The defendant has no right to come in and assert some contractual obligation between the FBI and this third-party service to try and get this evidence suppressed. He would have to show that he has a reasonable expectation of privacy in these companies. And I think if he could show that, he would have by now. The fact that he hasn't strongly suggests that there would be no Fourth Amendment argument to make. I also find it quite telling that with the two defense attorneys that took the stand today, who both claim to deal in this area a lot, the defense hasn't been able to provide a single court that has sided with them on this issue. Not one. We've supplied two in California, there are more, that have all found this just doesn't matter. Well, and why doesn't it matter? And I would point to the testimony of their own witness today, Your Honor, the one that was just disclosed yesterday, Ms. Vargas. When you listen to her, a couple things really stand out from her testimony to me. Number one, she doesn't have a scientific background. I think she had a bachelor's degree in criminal justice and administration. And no science to that, no science component, right? It's not scientific at all. But she has successfully given 50 tips to law enforcement that have panned out, which is great. Kudos to her for that. But what does that tell us about the process? Well, it tells us that the IGG process itself is not a scientific process. The science, as she indicated in her testimony, is done by the labs. That's why she uses those labs to do those things. And that's what we've provided them. Everything to do with the STR testing and comparisons, we have disclosed. Everything with the creation of the SNP profile, the SNP profile itself, we either, I'm not totally certain on the status, we either are disclosing it or it has already been disclosed. So they're getting that as well.
Can I ask you a question about that? Because also in the brief, it talks about what the state is not seeking to protect and has and will disclose. And the first item is the genotype kit report from the private lab used by the ISP, which documents that the DNA test was performed. Is that is that the STR kit or the genealogy?
Yeah, sorry, Your Honor.
Go ahead.
Great question. The what's being referred to there is the genetic genealogy, the SNP profile. And I wasn't as clear as I could have been in that initial brief. I think I made it clear in the reply, though, that we either have or will produce the SNP profile. And so, yes, was the SNP profile the result of a scientific test or experiment and therefore disclosable under B5, I believe it is? Yes, it is. But my point is, after you've done that, law enforcement then goes on and uses that SNP profile to do this IgG work. And that gets back to my point that that is not a scientific process. Again, their witness has no scientific background, yet she's able to do this successfully.
So let's kind of address that for a moment, because you send the SNP to the FBI, and initially it was at his service, and then the FBI took over of that. Then they go through some kind of system in a computer. Is that not scientific?
Well, again, Your Honor, the words matter in Rule 16, and it doesn't just say scientific. It says, on written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy any results or reports of physical or mental examinations and of scientific tests or experiments. So it's not just a question of, is it scientific in any conceivable way? It's, was this a test or experiment? And running something through a database, I don't think we would classify that as a scientific test or experiment.
But it's comparison. It's comparison different people's DNA, and then it spits out a report where there's some relationship among all these people. So that's the result based on some type of scientific process, I would think.
So, no, Your Honor, I mean, the state would disagree that putting something in a computer and having it spit something back out is a scientific test or experiment. If it's the results of that, it would be that list of individuals, not the later created family tree.
Isn't there a process where they're comparing their DNA? I mean, isn't that scientific?
Not as part of after they get that initial list, that's when, as Ms. Vargas testified, that's when she comes into the mix and takes that list and runs with it and does her thing. And again, Ms. Vargas doesn't have a scientific background. That's my point, is that the investigative piece of this is not a scientific test or experiment. So the lab piece is, yes, and that will produce them. But once you get into this IgG stuff, then it's not a scientific test or experiment. And so that's where we are saying, look, we'll disclose all of this lab stuff. And the other theories that they've asserted here, for example, going back to the STR, the SNP thing affects the statistical analysis for the STR. Well, again, we're giving them the SNP profile. If they have experts who want to try and compare those two things, they're free to do so. Now, we've submitted the affidavit that suggests that that's not even a thing that's possible, but if they think that it is and they'd like to do it, they'll have those things and they can do that. Your Honor, I'd also, another thing I want to make sure that I emphasize today is this motion came in kind of a two-step process. The first request is that you agree that just as a logical matter, Rule 16 doesn't apply and they're not entitled to this information. But if this court finds that, hey, you know what, maybe there's something here, maybe Rule 16 does apply, well then the process the court is supposed to use is to hold an in-camera hearing. And the reason why it's in camera is so that we can present to the court the very information that we're seeking to protect. I think probably everyone in the room recognized today that a lot of what happened today was in some ways kind of beating around the bush. And that's not a criticism in any way of what the witnesses did. They can't say what they don't know. But there is a mechanism we can use whereby we present to you exactly what happened in this case, and then the court can make the determination. Does this fall into Rule 16? Is it exculpatory? Right? Does it need to be disclosed here? And so that's the two-step process that we've asked for. If the court believes that it falls under Rule 16 for some reason, or there may be something exculpatory here, then the court should allow us to present to the court the information we're seeking to protect, which again includes the names, dates of birth, and genetic and familial relationships of hundreds of innocent civilians. I know this court is fully aware of how high profile this case is, and the risk of something like that getting out, what it could do to those individuals, it's not worth taking that risk without at least first taking every step we can to ensure we really should be disclosing this stuff. The other thing I wanted to talk about is, there's Rule 16, and then there's also the Constitution. Those are kind of the two sources of authority they cited for why we may have to disclose this. But when it comes to the Constitution, for me, I think it's easier to start with what the Constitution does not require. And I'm just going to read this. It's from Idaho Supreme Court case, Dunlap v. State, 141 Idaho 50. And it says, there is no constitutional requirement that the prosecutor make a complete and detailed accounting to the defense of all police investigatory work on the case. So we have to start with that proposition, because if that were otherwise, then we would just always have to disclose everything, and we never have to have these hearings, which would be a benefit, of course. But the point here is, in some ways, they are arguing explicitly that they have that right, but the Idaho Supreme Court has already said they do not. In their brief, they said that. Here today, it's much more implicit. And what I mean by that is, they'll say something like, well, Your Honor, maybe the FBI broke the rules, maybe the FBI didn't. There's no way we can know unless you give us that information. Well, you can say that about anything. Maybe when they were doing this one piece of the investigation, they followed their internal procedures, maybe they didn't. And if that's sufficient to get disclosure, then what the Idaho Supreme Court here said is invalid. It conflicts directly with what they said. So the mere possibility that the FBI or some other law enforcement agency violated the terms of service, that alone should not be enough to force disclosure of the information. Because otherwise you're going to run into this issue where you just have to disclose the entire investigation every single time. Now, I also want to talk a little bit about, a little more about Mr. Mercer and his testimony, because you know, they talked about there's this minimum standard of what's required in order to turn the DNA evidence over. And he practiced, he said, in D.C., Maryland, and Virginia. And there, he said that the defense attorneys must obtain discovery of the DNA sample. I would just ask the court to kind of reflect on that argument for a second. The argument being posited is the defense has an obligation to investigate, therefore we have a right to all of the information to investigate it. That just defies logic. Yes, defense attorneys have a duty to investigate, but that duty doesn't override the rules of discovery and the Constitution. They don't just get to say, well, we want to see that because we have a duty to see things. That's not an adequate basis on which they should be able to get this discovery in this case.
Let me throw potential logic here for the judge, because this is a death penalty case, and what I think was being suggested is you have sort of post-conviction arguments about we weren't provided what we asked for that could have made a difference. And if we don't do that, we're going to be accused of being incompetent lawyers. So, see where I am.
Absolutely.
And where they are.
Absolutely, Your Honor, and I appreciate that. I guess just a couple of things I would say in response. One, I've worked on quite a few post-conviction cases, and I promise you there will be no shortage of allegations. I think that the court and counsel will go crazy trying to figure out, down the road what could possibly argue and use that as the basis to make decisions today.
I'm trying to minimize.
Totally understand, Your Honor. My point is just there will be allegations down the road in any criminal proceeding. Second, this has been kind of alluded to twice today, and in some ways it's the elephant in the room that this is a death penalty case, and death is different. True, but discovery is not. If the Idaho Supreme Court wanted a set of rules that applied in death penalty cases that's different than Rule 16, they could have done that, but they haven't. And in fact, the quote that I read you from Dunlap v. State, that is a death penalty case. That's post-conviction in a death penalty case. So there's no trump card for death penalty discovery. That does not exist in Idaho or in any court in the country that I'm aware of. So, Your Honor, the bottom line is the state believes that it has shown that what we're talking about here, the STR stuff, totally understand. We're using that at trial. We're putting on witnesses. We disclose all of that information. They are, of course, free to attack that with whatever experts they so choose. But when you're talking about the investigative genetic genealogy, the SNP part of this, it simply doesn't matter. Again, to use their witnesses' own words, all that process did was provide an investigative lead. That's what she called it over and over again. And in fact, she said on the stand, it is then up to the law enforcement agency that I provide that lead to figure out whether to confirm my findings. And that's what happened here. The FBI provided this lead, and then law enforcement, multiple agencies, worked together to confirm what was done there. And the confirm is what matters. The initial SNP result, there's a reason we don't use that in our affidavits and why we're not presenting a trial. It's not because we're trying to hide anything, it's because it's not good evidence of guilt. You heard them talking about today. You submit this stuff to a database and you get a bunch of results back. Some people don't even use their real names. There's a bunch of unverified information in there. This is pretty far from a scientific process. It's a bunch of people getting together, paying some money to a corporation, and finding out what they think is interesting information about themselves. We can't stand on that for a probable cause affidavit. So we don't include it. It just has no relevance on the issues that matter. And the issues that matter are guilt and punishment. And because it doesn't go to either of those issues, then it doesn't have to be disclosed under Rule 16 or under the Constitution. Thanks, Ron.
One more question, I'm sorry.
Of course.
I'm curious because It's not clear to me in the briefs whether in getting the warrant, okay, for the saliva from Mr. Kohberger, whether the genealogy DNA was used to support the warrant.
I believe I know the answer to that. Can I just confer real quickly
Yes.
to make sure that I... So I was correct, Your Honor. No, it was not relied on any arrest warrant, any other kind of warrant has not been relied on as evidence of guilt.
Not a search warrant to get that.
Not a search warrant either. Correct. Yep. No, it was used exactly how we have characterized it, which is as an investigative lead.
Not being accusatory.
No,
It wasn't clear to me as I read that. Because I haven't seen the warrant. I don't know what's supported in the warrant, so thank you.
You're welcome, Your Honor.
Okay, any response?
I do want to respond.
Of course. Thank you.
I'll be brief, Judge. I want to start with saying that Mr. Mercer did testify that he didn't have a problem in his jurisdictions getting this genetic genealogy discovery. And we didn't go into specific cases because I believe at the outset of this case, there was concerns that we were going to try to get our witnesses to talk about legal conclusions and interpret case law. And so because of that, we didn't have any of the two attorney experts talk about specific cases and results. They certainly could have. But as it relates to discovery, Mr. Mercer testified that he gets genetic genealogy discovery and analyzes it. And we put before this court many other steps other than cross-examination that are used by the defense team to make decisions when they have in their hands the raw data. I also want to express that the entirety of today is based on Rule 16. The motion is based on Rule 16. And so why I didn't go through and read to you Rule 16. All of the briefing is about Rule 16, and all of the testimony certainly was about how the underlying evidence that we're asking for is scientific, and how there is a substantial need for it, and multiple examples were given to you. In terms of whether or not it's scientific, just to give you a couple of examples, the matching algorithm that are used in GEDmatch and family tree DNA, that's scientific. You've heard about centimorgans that a specific number is used by the person who builds the family tree, and what centimorgan is available and how wide or narrow they may use that as they're building that family tree and backfilling it. That's certainly scientific. The centimorgans, which are based off of the SNP DNA that's used. The state argues that, because we don't have Fourth Amendment motions to suppress before you, we can't produce them. Well, it would be disingenuous for us to brief based on evidence that's not in our possession that we're asking to have. In addition, the state argues that their agent, Hyles v. Whitley, United States Constitution, agent, the FBI, doesn't have to produce that. Constitutional law is absolutely contrary to that, and the FBI has produced thousands, anywhere from 13 to 25,000, we're not quite sure yet, of tips in this case, but the one magic tip, they want to fall on our agent hasn't given it to us. I started my argument to you with issue an order that says their agent under Hyles v. Whitley must produce, or this court has the authority to exclude it. And if you use your authority to exclude it, because you control the evidence that comes in this courtroom, it's guaranteed that the TUI letter is going to get the FBI to produce the DNA evidence, just like it did the Comcast report and the vehicle evidence. Because the FBI is going to listen to this court's order. And the idea that an ex parte hearing is going to be the cure to this is also not a solid argument. You don't get to decide, Your Honor, what the defense does with the evidence. You get to decide the arguments that we bring before you. We don't get the state doesn't get to put evidence in front of you and then decide ask you to decide in an ex parte hearing and tell us what we're going to do with it. We get the evidence, we do our investigation, we do our effective assistance of counsel, we consult with experts, and we decide with that evidence what we're going to do. A protective order would allow everybody in